Regulations Q&A session on the Simplified Procurement Regulations. I am Tamara Roy, Head Corporate Communications, and we're extremely pleased that you are able to join us today. In the room with me are our Chairman and Procurement Regulator, Ms. Beverly Khan, who will address you briefly before the session begins, followed by two presentations, which will be conducted by Ms. Pastora Brown, Head Procurement Policy Development, and Mr. Aleem Bashk, our Head ICT. To support the Q&A segment, we also have our Head of Legal, Ms. Lindian Mitchell, and the Head Procurement Capacity Development, Ms. Marisa De La Rosa, and other support staff. Before we begin the formal aspects of today's proceedings, please allow me to go through some helpful tips for a successful session. Do note that your mics will be muted during the session. Any questions that arise can be sent via the chat option on the Teams platform. These questions will be collated by our team and addressed in the Q&A segment after the presentations. We do acknowledge that some questions have been received before, and we will address those before we get to the chat aspect of the Q&A. Please keep your contributions helpful and be considerate to our presenters and other participants. Please note that during this session, we will be recording, and the recordings will be shared via email and uploaded to our website. So without further delay, please help me to welcome Ms. Beverly Khan.
Thank you, Tamara, and good morning to Chief Executive Officers, Permanent Secretaries, Accounting Officers, Procurement Officers, and Legal Officers. Thank you very much for your overwhelming response to attend today's Q&A session. This morning, we are here to share with you some basic information and to field your questions as it relates to the newly introduced Simplified Procurement Regulations, which came into effect quite recently. And these regulations really came out of having seen what has transpired since we had full proclamation of the Public Procurement and Disposal of Public Property Act on April 26, 2023. And in discussions with the Ministry of Finance, it was agreed that we needed to provide some measure of flexibility to public bodies to conduct their procurements without more efficiently, but without in any way working against the objects of the Act, as well as the regulatory oversight of the Office of Procurement Regulation. We had extensive discussions with the ministry and some of our stakeholders. We listened to what was indicated to us in our regional consultation sessions with public bodies and the challenges that you have been experiencing over the past year. And we acknowledge that the challenges have been quite traumatic for you in coming to terms with the new procurement system in Trinidad and Tobago. And is within that context that we set out to provide the relief without, of course, in any way removing the oversight of the regulatory body, the OPR, and without in any way diluting the objects of the Act. So we are here today after extensive consultation and having taken this process forward to share with you. We gave you a little time to digest the new regulations so that your questions could come out of having read the regulations. And if you need any further points of clarification or some more details, that's what we are here to do. So this is the first in Q&A session. We will be having another one this afternoon because, of course, The response from our public bodies has been tremendous, and we could not take everyone into this morning's session. So without further ado, I want to thank you very much for being present today and for engaging with the OPR. We will continue to use this mode of operation as we move ahead to grow and refine this public procurement system here in Trinidad and Tobago. We understand that there are challenges, but this is already an indication that the OPR is prepared to listen to your challenges and to find effective solutions so that there can be increased efficiency in the public procurement system in Trinidad and Tobago. So thank you very much, and I would now pass you on back to Ms. Roy for the commencement of our presentation this morning.
Thank you so much, Ms. Khan. We will now ask Pastoral to join us at the mic. So she will be taking you through the Simplified Procurement Regulations 2024.
Thank you, Tamara. Good morning, everyone. So today, our presentation will seek to provide an overview of the simplified regulations. So this session is really meant to give the public bodies the opportunity to ask questions on the regulations that you would have been reviewing over the past month or so and actually working with during this time, and to allow the OPR to learn from your experiences and, where required, provide additional information that might help to bring further clarity that you may require as you have begun to utilize these regulations. So this is not a traditional training session. We will just very briefly touch on some of the elements of what is contained in the regulation. We will do this as quickly as possible to afford you the time that you require to ask your questions, and let us have some meaningful discussion in this regard. So with respect to these simplified public procurement regulations, of course, we are aware that these regulations are meant to address public procurement proceedings that do not exceed $1 million, inclusive of taxes, duties, and other charges. With respect to these regulations, some of the things that you will find as you go through would be a definition for emergency, so that should bring some help to all public bodies. You will recognize that there have been two thresholds placed within that $1 million limit, and there are regulations that apply to, first threshold, micro procurements, which will be your procurements under $75,000. And then there are regulations that will speak to small scale procurements, which will be those above $75,000, but less than or up to $1 million. Something else you will see that should be helpful in these regulations will be the reduction of the time limits for making submissions of bids, quotations, and proposals. The regulations seek to define the roles of the named procurement officer and the accounting officer or delegated persons as far as it obtains for simplified procurements. There is a requirement for suppliers and contractors to be registered, and my colleague will delve more into that when he comes in to speak. The regulations also introduce a new procurement method called direct contracting, which will bring additional clarity and assist in the achievement of the objects of the Act as far as efficiency goes. The regulations reinforce splitting of procurement as an offense. And of course, it also speaks to how do you, in the first place, estimate your procurements, as well as these regulations establish reporting requirements that the public bodies must adhere to when reporting on a quarterly basis to the OPR. Okay, so let's just jump into it. Public procurement. One of the things we want to be aware of is the simplified procurement still remains a part of public procurement in Trinidad and Tobago. So while there are specific rules that will apply to simplified procurements is simply a subset of public procurement in general. Public procurement, as we are aware, is governed by the Act. So for the procurements over $1 million, we have the 10 regulations with which you are already familiar, as well as the handbooks with guidelines that are issued by the OPR, and all of these are found on the OPR's website. With respect to the simplified procurements, we now have the simplified regulations of 2024. And the handbook with guidelines, because as you went through the regulations, you would have noted references to guidelines to be developed by the OPR. So those are well underway, and we expect to have those issued to the public bodies within the shortest possible time frame. In the interim, we know that you are being guided by the regulations with respect to your simplified procurements. Okay, so just little technical glitch here as we continue. So moving on to the next slide. Moving on to the next slide, if it will cooperate. There we go. So what remains mandatory for public bodies under the simplified regulations? And Chairman would also already have mentioned, first and foremost, adherence to the objects of the Act. And we know what these are, so I will just skip reading them out. What remains mandatory? Regulatory oversight by the OPR. What remains mandatory? Incorporation of all stages of the procurement proceedings as far as is practicable. So we know that those stages involve planning, tendering, evaluation and award, and then contract management to close out. One of the things that you will find in the guidelines once they are published will be case studies. So that term, as far as practicable, will be further explained and clarified within the guidelines. What remains mandatory for public bodies? Of course, we already said it, reporting to the OPR, as well as maintaining the record of public procurement proceedings. Another key element that remains mandatory for public bodies will be the exercise of the due diligence requirements for the procurement activities. So law and order still remains and governs the public procurement proceedings. And so what is no longer required under these regulations? Review by the PDAC is no longer required, so you do not have to wait until a PDAC convenes a meeting and goes through the procurement file in order to award a contract that is less than $1 million. What is no longer required? The application of the standstill period is not applicable to simplified procurements. public notice of awards is no longer applicable for procurements under $1 million. Instead, for small scale procurements, that is those over 75,000, but under or up to $1 million, the public body will be required to advise the bidders that would have participated in the procurement proceedings of the result of the procurement, of the procurement activity. Another thing that will not be applicable under the new public procurement proceedings will be, for simplified procurements, will be the publication of micro procurements in the public body's annual schedule of planned procurement activities. In addition to that, there are certain requirements and exemptions with respect to the registry, and Mr. Alim Bashk will speak to those issues in greater detail. So we always want to ensure that we err on the side of caution. So we want to be aware that a simplified procurement must be carried out in accordance with the simplified procurement regulations. Because very similar to the procurements over $1 million, where a simplified procurement is not conducted in accordance with the regulations, simplified regulations, any procurement contract or agreement for simplified procurement will become null, void, and illegal. Another safeguard that we want to be aware of is that a procuring entity shall not issue a solicitation based on personal preferences and shall not restrict a solicitation to well-known suppliers only or contractors or to widely distributed brands. And this particular caution here, of course, is very important because you would recognize that these regulations provide the public body with a great deal of flexibility to make its procurement decisions. And that has to be balanced with ensuring that, notwithstanding that the public body always keeps in mind the requirement to promote the objects of the act. So we want to balance our liberty in such a way that we do not take license to breach the regulations. So let us just speak very briefly about simplified procurement methods and procedures. So as you can see on the screen, for micro procurement, the public body is able to engage in direct contracting and any other procurement method in the Act regulations and general guidelines. So these other methods will, of course, be limited bidding, open bidding, single source selection, or sole source selection. For micro procurements under direct contracting, procedures may include receiving verbal quotations that the public body will then have to be very careful to document in the appropriate form that is provided as a schedule to the regulations. So again, you are seeing where the flexibility is. So we want to be very careful how we balance things. For small scale procurement, any other method, and we spoke of those. So it will be open, it will be limited, it will be single source or sole source. However, direct contracting will not be permitted under these regulations for small scale procurements. And the good news that public bodies would have been waiting for And this has to do with the time limits that have now been established via these regulations for allowing your suppliers and contractors to make their submission. Now, and I want you to, in looking at the particular regulation that treats with these time limits, please pay very close attention to the fact that these are minimum time limits. And so the general guidelines will provide additional guidance that will help the public body to balance its actions so that it is able to achieve the objects of fairness, efficiency, and so forth to the as it relates to your suppliers and contractors. So please take a look at the time limits. Very nice periods being afforded as minimum requirements. And as you develop your procurements in your procurement strategy form, as you search the market and see how it operates, then you will determine whether would it be wise to give the minimum time frame, or would you need to add a couple more days to ensure that you get bids that are responsive to the requirements of your solicitation documents. So for open bidding, the new time limit is no fewer than 10 working days. Limited bidding, no fewer than 7 working days. Request for quotations, which we have as not so much as a method, but as a procedure, no fewer than 2 working days. Single source and sole source selection, no fewer than 5 working days from the issuance of whatever or publication of the solicitation document or procurement notice. So that brings me to the end of the general information with respect to the regulations. I would now like to invite Mr. Alim Bashk to join us to speak about registration for suppliers and contractors.
Thank you, Ms. Brown. Good morning, ladies and gentlemen. So in registration, so let's take a look at what the requirements are here. So for micro procurement, which just to reiterate, that's for less than equal to $75,000. For public bodies, there's an introduction of a new registry. It's called a public body registry. And this registry has to be maintained by public bodies. And this can be done in either an electronic or manual format. So the public body will determine which format they wish to manage this in. Some of the pieces of information which is required to be captured at this point in time will be things relating to the supplier's name, national ID number, the type of the supplier, the address, contact number, type of business. All right. So if we look now at the next level of procurement activity, which is the small scale procurement, we will still need to utilize the procurement depository. But in this case, the type of information that's required for registration will be less than what you're accustomed to for suppliers from a pre-qualified level. So the information here again is listed, and it's listed in the regulation. So you'll be looking for the name of the supplier, the address, the supplier contractor type. So that's whether it's a limited liability, sole proprietorship, etc., the nature of the business, geographic location, lines of business, etc. And for procurement activities which are greater than $1 million, for now, suppliers and contractors need to continue to go onto the depository and request pre-qualification and to become pre-qualified before they can engage in any procurement activity with public bodies. So who can engage with public bodies? So looking at the micro procurement. So for micro procurement, public bodies can definitely engage suppliers who are on their registry. Now, if, for instance, a supplier is not on their registry, they can still continue to engage with that particular supplier contractor, but they must ensure that they record that supplier contractor information in their depository no later than 21 days after the award of the contract. For the next level, in terms of the small scale procurement, again, public bodies can engage definitely suppliers and contractors on the procurement depository. If, for instance, the supplier contractor is not on the depository, they can still engage with that supplier contractor. However, do note, and very important, that the supplier contractor who is selected is registered in the procurement depository prior to the award of the contract. So if the supplier contractor has not been registered in the depository at the time of the award, then you can't award the contract at that point in time. So looking at consultants, so consultants, very similar to suppliers and contractors in terms of the format. Public bodies for micro procurement can engage definitely with consultants on their registry. If again, there are no consultants on the registry, they can engage with them. However, must ensure that they are entered on the depository no later than 21 days after the award of the contract. For small scale procurement, consultants should be registered on the depository and public bodies will be able to utilize them. If, however, there are no consultants registered on the procurement depository and the consultant can provide the service, the consultant can be engaged, but do note that they must be registered on the procurement depository prior to the award of the contract. So you need to make sure that those things are done before to make sure that you are compliant. And this allows some flexibility, which you didn't have before in terms of engaging contractors and suppliers and consultants who were not pre-qualified on the depository or who weren't even on the depository. Again, and also to note, in terms of foreign suppliers, again, most of you or some of you might have encountered resistance from foreign suppliers actually coming onto the depository, thinking that it didn't worth their effort to come onto the depository to be registered and pre-qualified. Now, again, foreign suppliers can be engaged, but prior to the award of the contract, the supplier, the foreign supplier, must be registered on the procurement depository. There are some exemptions which are introduced as it relates to registration, and these include payment to public utilities. So for instance, TNTech and WASA, they don't need to be registered. However, things such as telephone and internet service, those persons will need to be entered on the depository. We have things relating to the acquisition of goods or services, which is only available via online platform. So for instance, if you're acquiring services where there are no sales contact and it's only online platform, these persons or these services are exempt. If there are any goods, works, or services that are required for conducting the affairs of Trinidad and Tobago outside of Trinidad and Tobago, those suppliers do not need to be registered on the depository. And again, these exemptions are specific for the micro procurement and small scale procurement, which is basically procurement activities less than or equal to $1 million, inclusive of taxes. If there are procurement activities relating to air travel, hotel services, and other expenses related to conferences and foreign trade and training seminars, there are no requirements to be registered on either the public body registry or the OPR's depository. And in the case of goods, services, or works during an emergency, there is no immediate need to register these suppliers on the depository. As it relates to reporting, so for micro procurement, there are some changes relating here. So the types of reporting required from public bodies for less than or equal to $75,000, we're looking at a more summarized type of reporting. So the types of information or the volume of information that you would have previously provided before, that is going to be reduced. And the OPR is currently working on that template to be issued out so that you can report on that for Q3 of this current fiscal year. Do note that for the small scale procurement and for greater than 1 million procurement activities, there will be no changes in the reporting template in terms of the number of fields and the information that we are capturing. So there are no changes there. The reporting timeline, though, remains the same for all levels of procurement types, in that all activities need to be submitted to the office 3 weeks after the end of the quarter. Again, so any submissions after that timeline persons will be deemed as not being compliant. Right, so I would now like to pass you back on to Ms. Brown, who will take you through the requirements.
Okay, so thank you, Alim. Right, so as we would have indicated earlier, public bodies will be provided with, as usual, easy reference guides with respect to the regulations. So those will be sent to you later this afternoon, as well as they will be published on the OPR's website, because we want to have all the tools at hand that we can to assist us. But just by way of summary, we just want to run through very quickly the checklist as it applies now to micro procurement and small scale procurement. So just an easy reference. Annual procurement plan. Micro procurement must be included, as well as small scale procurement must be included, and needless to say over $1 million will be included. So it will be one annual procurement plan for all your procurements, but you will identify your micro and your small scale within your plan as well. In terms of the annual schedule of planned procurement activities, there's no need to include your micro procurements in the schedule that you will publish on your website or in electronic format, but you must include your small scale procurements on your schedule and publish the document. With respect to PDAC, there is no requirement for PDAC to review micro or small scale. There is no requirement for a standstill period for micro or small scale. There is no requirement to publish in electronic format or on your website your notice of award of contract or when you enter into a framework agreement. What is required here will be only for small scale procurement that the public body advise the suppliers and contractors that participated in the procurement of the result of the decision. So for micro, not mandatory, and for small scale, mandatory. Verbal quotations, I would have spoken to that, applicable for micro procurement, not to be used for small scale procurement. Direct contracting can be used for micro procurement, but not for small scale. Suppliers and contractors. For micro procurement, suppliers and contractors can be utilized from the public bodies registry. But for small scale procurement, suppliers and contractors must be utilized from the procurement depository. So you see here, yes for registry for micro, no for registry for small scale, no for registry for procurement depository for micro. They don't have to be registered, but they have to be registered for small scale. Quarterly reporting to the OPR remains a requirement for both micro and small scale, but the rules of engagement differ in that for micro procurement, the public body will be asked to report their contracts and purchase orders as an aggregate of the category, and we do have the categories spelled out in the guidelines. And for your small scale procurement, you report as normal each contract or each purchase order or each framework agreement that you enter into. So that brings us collectively to the end of the high-level presentation this morning, and I will now hand you back to Ms. Tamara Roy, who will direct the rest of the proceedings.
Thank you so much, Pastora and Aline. So at this time, we will go into the Q&A segment of the session. As I indicated this morning, we will first address the questions we would have received before So I will ask Ms. Rhonda Joy Lewis to moderate for that particular section. She will read out the question for the team, and one of our team members, depending on the question, will address it. If you need further clarification on any answer given, you can continue to comment in the chat and we will collect those queries, comments, etc. Thank you very much, Ms. Roy, and good morning again to all stakeholders. The first question that was posed to the team via email was, will the procuring entity be charged? And this is with regard to part 2 of the general clause, section 5.3, regulation 5.3. And we'll invite our head of legal, Ms. Lindian Mitchell, to answer that question.
Regulations.
Thank you very much, Ms. Mitchell. Our second question is, can the single sole source justification for selection of one tenderer be approved by the delegated authority if the tender is within that delegated authority's limits?
So what it is we have to note in this particular question here is Regulation 9. And Regulation 9 prescribes for power of the accounting officer, right? Regulation 9 provides that the accounting officer of a public body has the authority to approve a simplified procurement in accordance with these regulations. And as such, he may delegate the authority in writing in accordance with the limits of financial authority and the structure of the public body. So it provides for that delegation. It does not limit such authority, though, to any use of a particular method. As such, once the procurement is undertaken, utilizing single or the sole source method of selection, is within the financial limits of the delegation to qualify as a simplified procurement. The person delegated can approve same. What it is you must note, however, is that nothing prohibits the procuring entity from limiting the accounting officer's delegation of authority with the use of certain methods. So I hope that is clear.
Well, thank you very much for that response, Ms. Mitchell. Some of our stakeholders were saying that they did not hear your response to the first question. So we're just going to ask if you can repeat that answer for the benefit of all. For the first question, just to repeat, the first question was, will the procuring entity be charged?
Right, so that question is with respect to Regulation 12, which provides for the prohibition of victimization, and Regulation 17, which prescribes for confidentiality. It refers to a person who contravenes this regulation is liable, right? So the response to that question is that in accordance with the Interpretation Act, it states that reference to a person is to be construed as reference to a corporation or an unincorporated body. So whilst these provisions may make reference to a person, it is not just limited to an individual.
Thank you. We'll move ahead with the third question. Will the OPR provide a standardized format to report a contract awarded?
Yes, so Aline would have just touched on the reporting aspect, the requirements, and the OPR is currently formulating a template to capture the said information required in Regulation 10.5, and same will be provided on the OPR's website. So we have different reporting requirements under these simplified regulations. So you will notice under Regulation 10, the responsibility of a procuring entity. So it's 10.5, where a procuring entity awards a contract to a supplier or contractor pursuant to sub-regulation 2. It shall immediately inform the office of the award of the contract. We also have reporting requirements under Regulation 28, as Aline would have alluded to. Sorry, 29. So that's the reports on micro procurement. And again, this reporting is at the end of each quarter, a report detailing the following information relating to micro procurement in the aggregate, the spend of each category of goods, works, or services referred to in the guidelines, the number of micro procurements undertaken relative to the category of goods, works, or services, the value of the procurements conducted in relation to the category, again, of the goods, works, or services, the method of procurement utilized, and the total number of micro procurements undertaken. So that is 29 relates to micro procurement. And if you move to Regulation 38, it prescribes the reporting of small scale procurements. Regulation 38 provides that no later than 3 weeks at the end of each quarter, a report on all contracts awarded and all framework agreements established during the quarter immediately preceding the report, and the report shall include the method of procurement utilized, the supplier or contractor selected, and the contract price. Another reporting requirement is prescribed in Regulation 47, and that touches and concerns the procuring entity shall submit to the office on a quarterly basis in accordance with the guidelines, a report on the status or outcome of each complaint made against it. So that is just to touch on all the different areas within the simplified regs, some of the reporting requirements.
Thank you, Ms. Mitchell. We now ask for a comment from Ms. Brown.
Okay, right. So just to add to what was shared by Head Legal, I just wanted to address reporting specific to subclause 10.5 in the simplified regulations. The context of the reporting here has to do, hold on. Right. This has to do with a one-time exemption that public bodies are required to afford to suppliers and contractors. So as we read through from subclause 1 come down, the regulations outline the manner in which the public body will afford this one-time provision to suppliers and contractors in an effort to assist them with two things. One, being able to join in public procurement proceedings for simplified procurements, but also assist them in recognizing that, hello, I need to get my affairs in order as far as the statutory requirements go, and the regulations have provided me with a one-time blind to make sure and get my business in order. As far as taxes are concerned, if I wish to continue to participate in procurement proceedings and receive an award of contract from a procuring entity. So with respect to Regulation 10.5, the short answer is yes, the OPR will be providing the form letter and much more. So Lindy would have spoken to a lot of what the OPR provides to assist public bodies with their reporting. Please be assured that we are continuing to work to provide guidance and support to the public bodies as they manage Regulation 10. And included with the support we will be providing will be a template. The template will include the requirement for the public body to name the supplier, provide the award date, and the expiry 6-month period date as well. So there are some guidance that will be provided here, but in a nutshell, the answer is yes. We will be providing the support required by public bodies for this reporting requirement as well.
Thank you very much for your response, Ms. Brown. We move on to another question. Part 2, Regulation 11. The time for suppliers to make submissions was addressed. In 2 days, is 2 days stated in C realistic? Tenderers are not submitting a bid as they may not see the email in time to get a price from their suppliers. The clause says no fewer than 2 days, and this gives the understanding that 2 days is a normal plausible tender period for suppliers and contractors to submit a bid all the time. The question is asking us to clarify that statement, and a reasonable suggestion might be for clause C to indicate no fewer than 4 days.
Right, so this particular question touches Regulation 11, which provides for the time for making submissions, right? And within that regulation, certain time limits were introduced for suppliers or contractors to make submissions. The person asking the question is alluding to requests for quotations in particular. That's Regulation 11C, where the request for quotation is used no fewer than 2 working days from the date of issuance of the solicitation documents. So what it is you will want to note is that the regulation provides for no fewer than 2 working days, which means at the end of the day that the procuring entity can easily stipulate more days than 2 if they wish, and if it is necessary to do so. So the intention with these stipulations, these time period, is to simplify and provide a level of flexibility within the process and avoid the unnecessary delays and reducing the time frames to be applied to the 2 days as opposed to stipulating longer time periods. So that will be our response with respect to that question.
So there's a comment on Part 2, Regulation 16.3. The clause should have specifically indicated that the verbal request for quotes should be from a procurement officer. This can lead to confusion as quotations from verbal requests may have ethical issues.
So again, question 5 treats with Regulation 16, the submission of quotations. So the regulation provides that the submission of a quotation in response to a request for quotation, yes, it is a formal bid, Subject to subregulation 3, the submission of a quotation must be in writing. It shall be in writing. 16.3, where a procuring entity is engaged in micro procurement, a verbal quotation may be submitted. 4 goes on to provide that where this verbal quotation is to be used, the procurement officer shall keep a written record of the quotation in the form set out in Schedule 1. So where the procuring entity now, they wish to utilize this verbal quotation, and given that this forms part of the procurement process, and the NPO retains at the end of the day all responsibility for simplified procurement, we will direct your attention to Regulation 8. It is understood that any request for the verbal quotations will be made by the named procurement officer or other authorized persons or persons authorized to do so. So the intention is not to limit the ability of making such requests to the named procurement officers, as this really may not be practicable and does not offer all procuring entities the type of flexibility that is intended with these simplified regulations. Right, so having regard to the nature also, the value and the risk of the procurement, as well as the public body's internal control framework, other persons may, yes, be authorized to request and or receive such quotes. However, what it is you will want to pay particular attention to is the subregulation 4 in 16, which provides that the NPO is to keep a written record of all the verbal quotations by utilizing the prescribed form. And it is to be noted that the form ensures that the NPO overarching responsibility is maintained for procurements.
All right, so again, in addition, you may wish to turn to the schedule at the back of the regulation, where we have the verbal quotation form. And so whoever is actually collecting this information verbally is the one who will be responsible for completing the form. So that person will complete the form, sign and date, put their name, and then there's also space on the form for the NPO to make relevant comments and sign off or not on the verbal quotation. So again, procedural safeguards, and as Lindy said, subject to the public body's structure and how it would have developed its internal controls internally.
Thank you for your response, Ms. Brown. Another question comes from Part 2, Regulation 19.1. As far as practicable, suggests that the requirements are relaxed in the core activities of the procurement proceedings and therefore not undertaking any of the steps in clause 19.2 to 5 shall not be mandatory. Is this indeed correct?
No. So if it is you turn to Regulation 19, it introduces the stages of simplified procurement. Yes, the section prescribes that in conducting a simplified procurement, a procuring entity shall, as far as practicable, incorporate the following stages. We have 4 stages identified here, which prescribes for planning, solicitation, evaluation of submissions, and award of procurement contract, and management and execution of the contract. Within these stages, we have different elements to be incorporated for each stage. So when we use the phrase as far as practicable, in no way we want to suggest that it is not mandatory. As far as practicable in this context is to be done or achieved to the greatest degree possible within the current circumstances for that particular procurement activity. And again, what it is we also would want the users to note is the word shall, because it makes it mandatory for the procuring entity to incorporate these stages as identified in Regulation 19 as far as practicable. It's also to be noted that as far as practicable also affords the procuring entity a certain level of flexibility when satisfying the requirements under Regulation 19. And it takes into consideration that in some instances, maybe one or more of the requirements outlined in A to D may not apply. So maybe Pastora may be able to give some particular examples, direct examples relative to maybe where some of the sub-elements, if it is we look at them, may not apply.
Right,
Yeah.
that's correct, Lindy. So let's say, for example, we would take 2C, development of specifications for the supply of the goods, works, and services. So the key word in Lindy's explanation there would be the degree to which it is applicable. So the level of effort that the public body will invest in the planning, in the solicitation, in each of the 4 stages, as well as the degree to which you would develop documents for record keeping. What I can say is that when we issue the guidelines, we will have we will include there some case studies, and we will work towards providing guidance to public bodies for each steps of the procurement cycle. So let's say, for example, and I'll just use, if you are going to procure a ream of paper, do you have to sit down and develop a 3-page specification? Yes. So things like that. So based on the size and the nature of the procurement, will speak to the degree to which you will involve yourself in each stage of the procurement proceedings. The key thing here, though, is for the public body to always be conscious that there are these 4 stages. So when you sit to plan your procurement, so whether it's a very simple procurement or it moves through a spectrum to one that is more complex under the $1 million, you want to still consider. So I'm going to buy paper. What is involved in planning here? I'm going to buy paper. What is involved in solicitation here? And this is how we want the public bodies to think. So you think through each procurement and you document appropriately. And as I said, we will still try to provide additional guidance and support to help the public bodies who may still not, who may need additional clarification with respect to the degree to which they need to involve themselves in the various aspects. Because again, when we think about the objects of the act, one of them is efficiency. So is it going to be efficient for you to sit down and develop a request for quotation document if you need to procure paper or water? You still have to prepare something. You still have to specify what you need, but to a lesser degree. Yes? I hope that helps with the explanation.
Thank you for that clarification, Ms. Brown. Part 3, Regulation 19.4E. Is approval from relevant delegated authority applicable?
So this question touches again on the same regulation 19, but 19.4E. 19.4 introduces the element of evaluation of submissions and award of the procurement contract, which includes appointment of one or more evaluators, evaluation of the submissions in accordance with the evaluation regulations, preparation of an evaluation report, and 4E, obtaining approval from the accounting officer. So yes, where the approval of the accounting officer has been delegated as permitted under Regulation 9, approval from the accounting officer pursuant to Regulation 19.4E will capture, of course, any such delegation.
Thank you. Part 3, Regulation 24.4E. Can too many pre-qualified suppliers be a reason to limit participation?
Right, so 24E introduces the element of record of procurement proceedings. And again, the importance of record keeping is stressed in this particular regulation. It goes on further to provide for making the record available for audits and investigations and reports to the office. It must be maintained or retained for 7 years after the completion or termination of the procurement contract or after cancellation. And again, the record of procurement proceedings shall be kept for as long as is necessary where the simplified procurement is the subject of an investigation, review, or litigation. So the question touches on Regulation 24(4)(e). E pertains to the reason for limiting the participation of suppliers or contractors where the participation is limited. So what we want you to note is that no, having too many pre-qualified suppliers or contractors does not justify you limiting your participation. Participation in such cases, and in accordance with Regulation 9(2) of the pre-qualification and pre-selection regulations, a procuring entity may conduct pre-selection proceedings to limit the number of suppliers or contractors who will be invited to make submissions. What it is you will want to note is that Section 28 of the Act also provides for a procuring entity to limit participation in procurement proceedings to promote local industry development and local content. If any limitation is to be introduced, it must be declared by the procuring entity, as well as the nature of the limitation and the reasons for same, and must also be included in the record of procurement proceedings. So with respect to 24(4)(e) and the limiting participation of suppliers or contractors where participation is limited, you will want to note that particular response.
Our next question submitted touches on the OPR registry under Part 5 Micro Procurement Regulation 26. Will the OPR provide a standardized format for the registry?
So with respect to Regulation 26, right, 26(1) provides for, it requires a procuring entity to establish and maintain a registry in accordance with the OPR guidelines. So it is not a matter of maybe still utilizing the procurement depository. This regulation prescribes for the procuring entity establishing and maintaining a registry in a manual or electronic format. Registry is also defined earlier on, and it means a register of suppliers or contractors who are registered by a public body in accordance with Regulation 26. So the OPR, as Aline would have indicated, will be issuing guidelines to address same and consider providing a template or standardized format to be utilized for public bodies. Note that for the purposes of registration on the public bodies registry, Regulation 26(3) will obtain, that is, the registry shall contain the following information in respect of each supplier or contractor: the name, the national ID number, where the supplier or contractor is an individual, the address, the contact number, the type of business, and description of the goods, works, or services. What it is you'll also want to note is that due diligence is mandatory for the purposes of the simplified regulations. Due diligence is addressed in Regulation 15. So where procuring entity is engaged in a simplified procurement, it shall comply with due diligence requirements as set out in the guidelines. So statutory documents as well as other due diligence requirements will be addressed in the guidelines to be issued by the OPR.
Thank you very much.
So just to add.
Yes, Ms. Brown, go ahead.
So just to add with respect to the question of due diligence, because it came under the question came under subclause 26. Due diligence requirements form part of the procurement proceedings, not necessarily part of the registry. So the regulations here are very clear in terms of the minimum information to be captured on the within the public body's registry. Yes, the guidelines will provide additional information and help to the public body. But as far as your due diligence requirements go, that is specific to the particular procurement. So you will want to identify the applicable ones during the planning stage of your procurement. And then you will want to include what documentation and information you require to conduct your due diligence within your solicitation document, and you will want to evaluate your due diligence requirements during the evaluation of your submissions.
Thank you for your comments, Ms. Brown. Okay, so under Part 5, Micro Procurement Regulation 27.3, what happens after 21 days if the supplier does not comply to be registered? The clause is silent.
Right, so 27 touches and concerns participation by suppliers or contractors in micro procurement. So subject again to Regulation 2 and Regulations 18, 21, and 22, where procuring entities engaged in micro procurement, it shall solicit the participation of suppliers or contractors in its registry. Subregulation 2 provides that where there are no suppliers or contractors in its registry who can provide that goods, services, or works required, a procuring entity may solicit the participation of suppliers or contractors who are not in the registry. 3, where procuring entity solicits the participation of a supplier contractor under subregulation 2, it shall ensure that the supplier contractor is registered no later than 21 days after the award of the contract. So what happens after the 21 days? The onus is placed on the procuring entity to ensure that the said supplier contractor is registered in the registry. If it is the supplier contractor fails to do such, the procuring entity could move to the next ranked supplier contractor.
We'll invite Mr. Alim Bash, Head of ICT, just to share some comments on this question.
Yes, so as it pertains to the registration, so just want to clarify in terms of what the expectations are in terms of public bodies. So it's not that the public body will be creating a system where the supplier will now have to go online and then register, as they do right now on the OPR's depository. This registry, will be maintained by the public body. So the public body has full control in basically entering and maintaining that database. So the onus here is the public body has to ensure and enter that data within 21 days of using that supplier. Yes.
Yes, that's correct. So that this responsibility here is that of the public body. So you award the contract, and the regulation allows you, because of course you are doing so many other things, 21 days to complete the supplier registration, but it is the responsibility of the public body to sue.
Thank you. Part 5 of Micro Procurement Regulation 29. Will the OPR provide a standardized format to report the awards for micro procurement?
Yes, most definitely, and we will be providing that really June.
And under Part 8, Regulation 47, will the OPR provide a standardized format to register all complaints?
Yes, a standardized format will be provided.
Very much. So at this time, we will move ahead. with some additional questions submitted. So we have another question under Regulation 36(2). The procuring entity shall utilize the standard bidding documents issued by the office. Are standard documents, for example, requisition and solicitation documents, optional for procurements under $75,000?
So with respect to that question, we will want to maintain the standard documents to be utilized to ensure, again, transparency and accountability in the process. The details, of course, may vary based on the nature and risk or value of, or the method being utilized. So the OPR maintains that as far as practicable, you maintain the use of the standard documents to be used during the procurement process.
Thank you. And our last question on this particular regulation, will the OPR issue simplified solicitation document templates for procurements under $75,000 and single sole source procurements?
Yes, so that is something we will consider, the option of rolling out some templates with respect to the that particular threshold.
Maybe I can help here a little.
Sure.
So currently on the OPR's website, there is a simple form that is placed there for low risk, low value procurements. It already exists on the website. But of course, we always aim to try to provide as much assistance as possible to our public bodies. So we are currently in the process of going through that document. While it's available for use and you can use it, we are going through it to make sure we provide any updated assistance that we can, and then that too will be uploaded. So we will most definitely be providing standardized documents and all of the support to public bodies that we are able so to do.
Thank you, Ms. Brown. So now we take your questions that were submitted in the chat section as well as the Q&A tab of this question. If our preference is not to set up our own registry for micro procurement, can we continue to depend on the procurement depository of the OPR?
Again, we would have addressed that question earlier on. So in accordance with Regulation 26, a procuring entity shall establish and maintain a registry in a manual or electronic format in accordance with the guidelines to be issued by the OPR.
Right, so therefore, it's not an option, it's mandatory, it's codified in the regulations, the public body shall.
Yes.
All right, we just have a question for confirmation. Both micro and small procurements are considered simplified procurement. Is this so?
Yes.
Yes. Thank you. Is the accounting officer required to approve small scale procurement?
Yes, in accordance with Regulation 9. Regulation 9 prescribes that the accounting office of a public body has the authority to approve simplified procurement in accordance with these regs. And it further provides that where he may delegate the authority in writing in accordance with the limits of financial authority and structure of that public body. So usually public bodies will have their own policy which dictates for the delegation of authority and the financial limits to be applied.
Thank you. Under section 9.
Sorry, let me just put a plug in here for handbooks of special guidelines. So as you prepare your handbooks of special guidelines, one of the things you can address will be your delegation of authority. And so that is how it is at the moment. And it continues so to be. It's just now that the public bodies are able to specifically address issues related to simplified and micro procurements as well. Simplified procurements, which include micro and small scale as well.
Thank you. Section 9, delegation of authority. Is the OPR approval required for a ministry's delegation of authority?
Yes, so we would have touched on that before. No, the OPR do not get involved in any approval regarding the ministry's delegation of authority.
Okay.
That is dictated by the public body's internal policy.
Thank you. When engaging in micro procurements, let's say doing a request for quotations, is it mandatory to do a formal request to the accounting officer? For example, tenders and procurement requests, or is it that the normal process, such as an email correspondence or memo, with the same information, the need, the procurement method, etc., will be acceptable?
Okay, if I'm understanding the question, it may be that the person is asking about what initiates a procurement, and what initiates your procurement will be your purchase requisition. And again, within the public body, the public body's internal control framework will indicate the officer or the level of office that will approve purchase requisitions, probably based on the value of the procurement. So we call it a purchase requisition. That's standard language. In some cases, it may even be called a procurement initiation form. I know that is what we would have used when we would have procured works, for example, because it's already a purchase requisition for works, but certainly a project initiation form has to be approved, because what we cannot have is the case of the procurement officer running out and doing procurement with no formal approval. So formal approval definitely is required to initiate any procurement activity. I hope that was the answer to that question.
Thank you, Ms. Brown. So we are moving on to another question. Notwithstanding subregulation 1, a procuring entity may engage with or award a procurement contract to a supplier or contractor who has not submitted satisfactory evidence of having fulfilled his obligation to pay all required taxes or contributions in Trinidad and Tobago, where the supplier or contractor is engaging in procurement proceedings pursuant to these regulations for the first time. The question is, I need clarification on what is meant by the first time. Can a supplier be engaged by public entity A for the first time, and then be engaged by company B for the first time, and so on, without fulfilling his obligation of taxes?
And the answer to that is no. Okay, and again, because there's a process in place to treat with how this regulation will actually be operationalized. So what will happen here is public body goes ahead and invites suppliers. I'm just trying to create a scenario. And of course, we can continue to refine it as we go along. But step one, the expectation is public body 1 invites bids from suppliers or contractors. So you send out your solicitation document. Your supplier or contractor, in responding, is aware of Regulation 10, so he does not have evidence of having paid his taxes and so, but notwithstanding that, he submits a bid or quotation. Public body goes ahead and he evaluates the quotation, and supplier or contractor, without the satisfactory evidence of having paid the taxes, turns out to be the one that is awarded the contract. So public body goes ahead and awards the contract. Now, and this is one of the tweaks that we are making to the solicitation document, because it is going to speak to how this is going to work. right? So your solicitation document will speak to this one-time waiver. It will speak to the responsibility of the supplier or contractor who does not have the satisfactory evidence, but who will still be awarded the contract. But according to the regulation, must provide the evidence of having remedied this default or this weakness in his own system within 6 months back to the public body. So the public body awards but reminds the supplier or contractor of this requirement. Immediately, the public body writes to the office and utilizing the format that will be provided, advise the OPR of this public body. The OPR then will place the list of all the suppliers and contractors who are benefiting from this one-time waiver on its website, so that whenever any public body is going to invite bids, they are required to check on the OPR's website to ensure that a supplier or contractor it wishes to invite or wishes to award a contract to, whichever comes first, as the system is now kicking off, make sure that that supplier or contractor's name is not there. Now, we can well imagine a supplier or contractor saying, aha, I'm going to submit a bid by public body 1 to 25 and capitalize on the first time waiver from 1 to 25. That is not the intention of the regulation. And so the public bodies will have to be on guard for this. The OPR's support here will be to ensure that we published in a timely manner, as long as you provide the information back to us in a timely manner, that listing, when the award was made and when the 6-month period was would expire. Once you receive the documentation from the public body, from the supplier or contractor, you can then advise the OPR again in writing so that the listing on the website can be updated accordingly. So we will have to work together. We understand the little pains that will be there at the very beginning, but once we get it running, it will work smoothly.
Thank you for your response, Ms. Brown, because the second part of that question would be how would the public body know if that supplier has already dealt with, and you would have answered that question, the listing would be made available on the OPR's website. So moving on, is the accounting officer only to be a CEO of a public entity? If yes, then can the CEO delegate the role of the accounting officer?
So regulation 2 prescribes the definition of accounting officer, and the definition is consistent with the procurement proposal of public property procurement methods and procedures. And if it is, you go to the procurement methods and procedures regulations, it prescribes that an accounting officer means a person appointed by the Treasury and charged with the duty of accounting for any service in respect of which monies have been appropriated by the Constitution or by Parliament, or any person to whom issues are made from the Exchequer account in accordance with the Exchequer and Audit Act, or the Chief Executive Officer or any other person holding the equivalent position in a procuring entity. So you will see in the definition that it includes the Chief Executive Officer or any other person holding the equivalent position in a procuring entity.
Thank you for your response, Ms. Mitchell. Another question submitted by a stakeholder for the micro procurement registry. Is it that the procuring entity needs to request their consent to be listed on the registry? Or is it that the procuring entity can simply add persons' names and businesses to their own registry?
So the answer to that is the second, is in that yes, they just need to maintain their own information. They do not need approval from the supplier to be added on.
Thank you. Will the reports in the depository have a category for registered suppliers, similar to how there are categories of pre-qualified suppliers and by location?
So currently, we do not have that report that provides a list of registered suppliers. That will be coming in due course, and that will also be coming along with an upcoming change with the procurement depository, where the system will be changing from a database of pre-qualification to database of registered suppliers and contractors. But we cannot make those changes yet until changes are made in other regulations, which are actively being worked on. So this is something which is a work in progress, and we hope to have that in place fairly soon.
Thank you for your response, Mr. Bash. This question takes us to part 1.3. It's reference to a fixed term contract, which does not specify a total price. How can the total contract value be calculated?
Right, so we are speaking here of estimating procurement. 6.3. Thank you. So this is regulation 6, right, in estimating the value of the procurement. Would you mind repeating the question, Rhonda, please?
Yes, no problem. So regulation 1.3 makes reference to a fixed term contract, which does not specify a total price. How can the total contract value be calculated?
So the total contract value will be calculated by estimating, let's say you wanted, okay, so they give examples here. They said for lease or rental. So let's say for the year, okay, let me bring it down to a month. Let's say that you have a monthly value, because remember here you are speaking about estimating the value of the procurement. So let's say you have an estimate for 1 month. In order to calculate your annual value, you will have to take your 1 month estimate and multiply it by 12. If your lease is for 3 years, to estimate the value of the procurement, it will be your 1 month value by 36 months. Yes, because in planning your procurement and in estimating your procurement, you are looking at what is the value of the contract over the duration of the contract.
Thank you for your response. Okay, so our next question is asking, can you expand a bit on direct procurement?
Like that.
Oh, sorry, go ahead, Lindsay.
Direct contracting. So we turn to part 4 of the regulations, right? Direct contracting is a new method that was introduced in the simplified regulations. And the direct contracting method was introduced to bring about some form of flexibility and efficiency within the system, right? We appreciated the fact that some procuring entities, they might have been engaged in some procurement proceedings that of not a complex nature. And with such, we wanted to create something that at the end of the day, we tie it to the lower threshold of to be used only for micro procurements. So you will see 25.1 introduces that the procuring entity may only utilize this particular method for micro procurements. And there are conditions by which it is you will use the direct contracting. Certain conditions are stipulated in A and B, right? Now, in using direct contracting, a procuring entity who decides to use such, it must obtain the approval of the procurement officer. The sub-regulation 25.3 thereafter introduces some safeguards to protect the use of the direct contracting, and where the procurement officer suspects or has a reason to believe that a price may not be reasonable when compared with the previous prices paid for the goods, services, or works, or the current prices for the goods, services, or works, he shall verify the reasonableness of the price to be paid. The procurement officer shall not approve the use of the direct contracting if he's unable to justify its use. Regulation 25.5 further touches on where the procurement officer does not approve the use of the direct contracting. A procuring entity may utilize any other method of procurement in accordance with these regulations. So yes, it is intended that the method, yes, only touches on the micro procurement aspect. It is reflected though, you'll want to know that direct contracting is reflected throughout the regulations. You would want to pay particular attention to regulation 25.1, 28, regulation 28, 32, and 24.5a. And it may be suitable where the public body needs an immediate good work or services, but it does not qualify as an emergency as defined in regulation 2. Right, it permits that direct contracting is to be utilized only by the authorized persons within the public body, whilst ensuring that the named procurement officer is ultimately responsible for the use of direct contracting. And it also serves to ensure that the public body is not hampered in utilizing the direct contracting method in any way. And it creates that level of flexibility, as I would have suggested earlier, since it is anticipated that there may be situations that may arise which warrants the use of the method. Pastora maybe could provide some further examples, maybe in situations where the direct contracting method is utilized. We would have come up with about 2 or 3 examples from before with respect to the catering services.
Thanks, Lindy. Okay, so once again, these set of regulations provide a great deal of flexibility to the public body, and the direct contracting method is one of those flexibilities that have been introduced. So even as we determine which procurement method is most appropriate, we want to ensure that we do not abuse the flexibilities that are provided in the regulations. We want to remember that we still have to achieve the objects of the Act. We want to remember that we still have to justify and maintain a record of procurement proceedings for each procurement activity that will justify why a particular procurement method would have been chosen. So we would have spoken about these regulations addressing the issue of emergency procurement, bringing further clarity to what we would have had in the original set of regulations. The direct contracting method, and Lindy would have used the word, is really meant to help public bodies who may identify during the course of their business a need that can be considered immediate, but does not fall under the definition of emergency as you have it in these regulations. So, as Lindy would have said, we did come up with some examples, and these are just examples that we think about as you go about your business. Other scenarios will present themselves, and you will then be able to recognize whether the direct contracting method is the most suitable for that particular procurement activity. So we are saying, for example, and it is all to be done within context. So the public body has its annual procurement plan. So it has its planned procurements, including its micro procurements. However, let us say, for example, the public body does not normally cater for meals. Now, if you normally cater for meals for the staff, you may have already considered entering into a framework agreement so that you are able to easily just order meals from your caterers when you have a planned meeting. But let's say you do not have a framework agreement, or you have an unplanned meeting that goes on for hours and hours and hours, and you recognize, no, we need to provide something here to eat. And it may be that you did not have time yesterday to book the caterer because you just became aware of this need. Then the direct contracting method would allow you to call, well, whether it's one of your caterers or whether it's a nearby business that will provide food, and order. So you may then utilize your verbal quotation, which you will document, etc., etc. So again, please do not get excited. Direct contracting is not meant for, oh my gosh, yes, get out of jail free card. Everything is direct contracting. There are rules of engagement. So that may be one scenario with which you would be presented where direct contracting, you may find it useful. Or a particular officer for a public body might be out working away from the office, and something happens. Your battery dies. Yes, you will not want to go through, okay, let me sit down and draft a request for quotation and develop specifications, etc., etc. So as I'm speaking, I hope you are beginning to understand what we mean when we speak to the degree to which you involve yourself in the procurement proceedings. So for a battery, for example, you may just want to be able to get this battery from the closest provider and install it in your vehicle and go about your business. So again, these may not be perfect examples, but they kind of give you an idea of how to start to approach thinking about using the direct contracting method. Let's say you are utilizing a piece of machinery in your plant and something breaks right there, and you are able to easily source a rubber or whatever it may be, right? Some piece of equipment to very quickly repair the machinery right then and there. You may decide, well, okay, for efficiency's sake, this is what I'm going to use. So this is the application of direct contracting and how it is envisioned. It is meant to assist the public body with its efficiency, so that you can continue with your business, etc., etc. It is meant to provide some relief, but as you see in the regulations, there are procedural safeguards so that there will be no abuse of this particular method.
Thank you, Ms. Brown. Our next question states, should all PDAC members recommend approvals to the accounting officer? What happens if 1 out of 3 PDAC members agree to recommend? Should the accounting officer approve the award?
So what it is the public bodies will want to note is particular is part 3, regulation 13. And regulation 13 provides that where procuring entities engaged in a simplified procurement, the following do not apply. So the review process with respect to PDAC, pursuant to regulation 21 of the procurement methods and procedures, that does not apply. It is disapplied from the requirements of simplified procurement. And simplified procurement, of course, includes both micro and small scale. Regulation 13 also provides that with respect to observance of a standstill period, Section 36 of the Act and challenge proceedings as set out in Part 5 of the Act is also disapplied. So challenge proceedings, so for simplified procurement, goes hand in hand with the removal of the standstill period. And of course, it is intrinsically linked to one another. So there have been a lot of research regarding this particular issue with respect to simplified regulations or below threshold regulations. And these particular conditions or provisions do not apply to simplified regulations. Challenge proceedings, standstill period, and Section 36 of the Act is the removal of the publication. Again, with respect to the publication, it's recording for the simplification of the process and creating a greater level of efficiency, removing the administrative burdens that some of the public bodies currently experience. So just to note that PDAC, standstill, challenge, and Section 36 requirement is disapplied from these regulations.
Thank you very much. Will the OPR give a format for the quarterly reporting?
Answered.
That answered already.
Will all these questions and responses be posted to the FAQ on the OPR's website?
So yes, the questions and answers will be compiled and it will form part of the tab under the FAQs on the OPR's website. So we will be taking on board all the questions and the responses, and we will be compiling and they are uploading on the OPR's website.
Thank you for your response, Ms. Mitchell.
So with, I was just looking at regulation 21. Just to confirm that regulation 21, international vendors are not required to register on the procurement depository.
That is still for one of
Provision.
provisions. However,
They are required on the 20th.
31,
Yeah. 31.
31.6.
Yeah, to register.
So in accordance with regulation 21, you will want to know that participation of foreign suppliers or contractors in simplified procurement, and that touches on the one-off provisions of goods, services, or works to be utilized outside of Trinidad and Tobago. It is not required to solicit the participation of suppliers or contractors on the public body registry or the procurement depository. So that is regulation 21, and thereafter it touches on concern regulation 31.6, and 31.6 provides that subject to regulations 18, 21, and 22, a supplier or contractor who is not a resident of Trinidad and Tobago shall be registered in the procurement depository prior to the award of a contract, and the procuring entity shall allow sufficient time and provide reasonable assistance to the supplier or contractor to complete his registration in the procurement depository. So as it relates to one-off purchases from foreign suppliers or contractors, you are not required to solicit participation of suppliers or contractors on the registry or the procurement depository. So I hope that is clear.
Yes, thank you very much, Ms. Mitchell. So we move on to another question. How is confirmation of funds to be interpreted? Is it sufficient allocation in the vote, releases of funds, or formal requests to the Ministry of Finance? And we will ask our regulator, Ms. Cam, to answer this question.
Yes, so good question. It is on the minds of a lot of public bodies. A sufficient allocation in a vote is not necessarily an indication of confirmation of funds. It essentially says that you have been allocated an amount, but whether that amount is realized is dependent on a number of factors. The issue of confirmation of funds, we acknowledge, given our interaction with several public bodies, that it is proven to be a hindrance in moving ahead with procurement activities. The matter has been brought to the attention of the Ministry of Finance to see if it is that we can use allocation with their blessings, if they can advise public bodies on the issue of allocation. But that matter has still not yet been determined by the Ministry of Finance. So this question is really with the Ministry of Finance and the Budget Division in particular. My own experience is that allocation does not mean confirmation of funds, right? Release of funds, when the money is actually sent to you, is when you could really confirm that you have it. But we understand that that is proven to be a challenge, as I said, and we have raised the matter with the Ministry of Finance to see if there can be greater clarity given to public bodies in respect of this matter.
Thank you very much for your response, Ms. Khan. Okay, thank you very much. Let's look at another question. What is the procedure if there is only one respondent to a tender or RFP? Is that considered a sole select or is it a single source?
Neither is the answer. Sole select or single source is when you actually invite only one. If you invite three, or if you have a public invitation and you only get one response, then that is neither a sole select or a single. I hope that my explanation is clear. When the response has nothing to do with whether or not it's a single source. You did not seek to get one. You sought to get a few and you got one. So it is not a single and it is not a sole.
Thank you very much, Ms. Brown.
There were several questions related to whether public bodies can still utilize a PDAC for small scale procurements. So it's not required under the Act, but if in your own internal processes you want to utilize the PDAC, by all means you can do that. There are other questions related to the membership of the PDAC. I should let everyone know that the matter of the PDAC is now under review in our discussions with the Ministry of Finance to see how we can make it a little bit easier for you to get your membership of PDAC in accordance with your own capacity. So we will be introducing some more opportunities for you to have your membership of PDAC, right? So that will come together with, there was a question regarding the changes to the procurement depository that we had signaled a couple months ago, well, more than a couple actually. And yes, we are in the process now, in the final stages of having discussions with the Ministry of Finance on the draft regulations. And we expect that within, I would say, the next 5 to 6 weeks, those regulations will come into effect, which will allow us to simplify the requirements on the procurement depository and to make it purely a registration platform as opposed to a pre-qualification platform. And in that process of revising those regulations, we are looking at we are also looking at the opportunity to simplify certain areas. And the PDAC is one area that we are looking at. We're also looking at the timelines for submission of tenders. So even for over $1 million, we are looking to reduce the timelines to make it flexible. In our approach to this matter is that, and I think somebody raised it in a question already, while you do want to give the flexibility to public bodies, you must bear in mind that suppliers and contractors must have adequate time to prepare their submissions. If you don't give them time, then you could have a situation where the procurement, you have serious issues with the procurement once the award is made, and that you realize that the intended objectives and deliverables under the project cannot be met. So we need to balance the need for giving public bodies greater flexibility with the need to give suppliers and contractors enough time so that they can prepare their submissions adequately. And I think that was what a previous question was alluding to. So we are bearing that in mind. Okay. So there are questions also with respect to whether you can use suppliers and contractors on your procurement, on the procurement depository, the OPR's procurement depository, and not have your internal registry. It is a requirement that you have your internal registry. If you want to go onto the procurement depository and identify persons that you can then register on your internal registry, by all means, you can do that. As we grow the system over the next few years, we do want to dovetail everything into one platform, but we understand the challenges that small suppliers and contractors have in coming on to the procurement depository, and therefore we are giving them the opportunity to be registered with the respective public bodies. But the public bodies must ensure that they do their due diligence as well. Because if for some reason there's an issue, the OPR will ask to see your files. We can audit your files and ensure that you did do your due diligence. So as we wrap up, we know we could be here for the entire day, given the list of other questions that we have. We will commit to posting on our website the responses. There's a lot of duplication, in terms of the concerns or the questions or the points of clarification that public bodies have. But in closing, before I pass back on to Tamara, I just want to use the opportunity to say that since full proclamation on April 26, 2023, we have been in a mode of supporting public bodies in several areas, but particularly the reporting requirement, right, as mandated in the Act. I have to tell you that in the first 5 months after proclamation, up to September 30th, 2023, we essentially had zero compliance. And some of you would say, oh, but I did submit. But yes, what you submitted was not in compliance with what was required. right? And since then, we have worked with public bodies, and we have been able to get out of the 232 public bodies on the procurement depository, we have been getting just under half of them to come into compliance with the reporting requirements, the quarterly reporting requirements. So it means then that 50% of our public bodies are not now in compliance with the Act and to report on their procurement activities. So those of you who fall within that group, I would urge you to please ensure that you become compliant. 3 weeks after the end of every quarter, you are required to report. Yes, we acknowledge that the reported requirements seemingly is onerous, but it is all the information that the OPR asks for is grounded in the requirements of the Act and the information that needs to be part of the report of the OPR that goes to the Parliament, right? So those of you who, for the last 2 quarters of this fiscal and the remaining 5 months of the last fiscal that did not report, you will be identified and recorded in the report as not being compliant. But there is still, the opportunity for you from the 3rd and the 4th quarters to become compliant, right? Those of you who have not published your annual schedule of planned procurement activities, it's a smaller amount. Please get ready for the next fiscal year to be able to meet that requirement. So thank you all very much, and I pass you back on to the head of corporate communications.
Thank you so much, Ms. Khan. Thanks to the OPR team who would have addressed all of the questions, and thanks so much, stakeholders, for actually sending in your questions to us. A gentle reminder that we will be preparing FAQs arising out of this session, and they will be placed on our website. We will notify you when we have done this. We will also send today's presentation and a copy of a simplified procurement reference guide for you, as well as the link to the recording of this session via email. So once again, thank you so much for joining us today. You may submit any further questions to us at feedback@opr.org.tt. Do enjoy the rest of your day, and thank you again from the OPR team.